Hi, my name is Robert Chelle with Chelle Law, and I'm an attorney that assists dental associates with employment contract and independent contractor agreement issues. Today I'm going to talk about dentist non-compete rules and risks. So what are some things you need to look for if you have a non-compete in your contract, and then maybe some solutions to make it a little better for you. So first, you need to identify whether you're in a state where non-competes are enforceable or not. There's a handful of states that have outright banned non-competes for providers, and so you need to identify if you're one of them. Many states over the last, I'd say, 3 to 5 years have started changing their non-compete rules. Some states have just started with physicians, and they haven't extended that to dentists or veterinarians, chiropractors. But I think it's leaning more towards states are taking more and more action to limit or restrict non-competes for healthcare providers. So my guess is over the next decade, it will continue to spread around the country. I don't think it's going to happen at the federal level with the current Supreme Court that we have. So if that's what you're banking on, I would not bank on that, and then hope that your state takes action to restrict or limit non-competes for dentists. All right, so what is in a non-compete? Well, it has 3 main components. 1, the scope, meaning what can't you do after the contract terminates. 2, the time restriction, how long does it last? And then 3, the geographic restriction, in what area specifically can you not practice as a dentist. So for scope, pretty simple as a dentist. It'll say you can't practice dentistry for 1 year within 10 miles of the practice. That would normally be considered a reasonable non-compete for a dental associate. Like in New York City, might be a block or 2 would be the absolute most geographic restriction that we would be okay with. Whereas if you're in a more rural environment, a larger restriction might make sense. One thing you need to make certain about if you're working for a corporate dental or DSO or something like that, and they have multiple locations throughout the city, you don't want language that says you can't work within 5 miles of any of their locations. You want it to be just the locations where you worked at. So let's say you filled in at, we're bouncing back and forth between 2 practices, then you would say, you can't work as a dentist for 1 year within 5 miles of both practices. But you absolutely do not want it to attach to anywhere that the organization has offices if you've never worked there. That's not fair. Second thing you need to think about, there should be a brief look back period. So let's say you have a non-compete that says you can't work, as I said before, for 1 year and within 10 miles of anywhere where you've practiced for the employer. You don't want it to say for all time. You want it to limit it to the last 12 months. So let's say you join an employer, you've been there 6 years, and then the first year they had you go fill in at an office 20 miles away. You wouldn't want a 10-mile restriction to attach to that location just because you worked there for 1 day 6 years ago. So you want it to say anywhere you've worked in the last 12 months or something like that, to limit the time period where it looks back and attaches to any of the locations where you provided care. Is this something that's negotiable? Absolutely. There's no rules that say it has to be one way or the other. There's a few states that absolutely dictate it can be no longer than 1 year and maybe no more than 5 miles or something like that. But for most of the states, it's a reasonableness standard. So this is definitely something you can negotiate. And for some people, it's very important if they grew up in a city, have family in the city, kids going to school. The last thing they want to do is leave. And so you want to make certain if you're in a medium-sized city where 20 miles would knock out the entire metro area, that you really try to get that geographic restriction down so you're not going to have to be either commuting for a very long way for a year or potentially even having to move to find a new position. It's pretty frustrating for any provider with a very restrictive non-compete. If you're an independent contractor, which many dental associates are, if maybe you're doing some fill-in work, you do not want to agree to a non-compete if you're a 1099 doing relief work or just filling in maybe a couple times a month. I've had a lot of problems with dental associates who are working multiple jobs and they've signed all these independent contractor agreements and they contain non-competes. And it really makes it a problem for them if they find like a full-time position. So if you're signing an independent contractor agreement, you want to make certain it does not contain a non-compete. It just doesn't make a ton of sense for you to work someplace, once every 2 weeks and then to say that you're somehow going to compete against them down the road. It's very difficult to build up a practice when you're working somewhere, twice a month. So those are some red flags for dental non-competes. If you have any questions about your employment agreement or independent contractor agreement, feel free to contact my law firm at the information listed below in the description. And I appreciate you watching the video. All right, thanks. Bye.